COVID-19 supplemental paid sick leave is back. A new law, which applies retroactively to January 1st, 2021, revives the previously expired requirement for many employers to provide supplemental paid sick leave for COVID-19 related reasons to their employees. California is opening back up after a very long time. Restaurants are reopening for inside dining. Movie theaters are serving up popcorn and films. Gyms and fitness centers are allowing members back inside. Schools are reopening. All this means that more and more employees will be returning to the workplace. And while the number of COVID cases continue to go down as the number of vaccinations goes up, there is still a risk that employees will be directly affected by COVID-related illness. In response, California has enacted SB 95, legislation that requires employers with more than 25 employees to provide 80 hours of COVID-19 related supplemental paid sick leave to full-time employees. Covered part-time employees are also eligible for the supplemental paid sick leave, dependent upon their work schedule. A part-time employee working a regular schedule is eligible to receive the total number of hours in supplemental paid sick leave that they were scheduled to work in the 2 weeks prior to taking leave. A part-time employee working a variable schedule is eligible to receive 14 times the average number of hours worked each day in the 6 months before the leave was taken. Employers are required to pay up to $511 per day and $5,110 in the aggregate to a covered employee for COVID-19 supplemental paid sick leave. Employers with 25 or fewer employees are not required to provide COVID-19 supplemental paid sick leave. These requirements are in addition to other paid sick leave already available to employees. Employees are eligible, and employers must provide COVID-19 supplemental paid sick leave to each covered employee if that employee is unable to work or telework due to any of these following reasons. 1. The covered employee is subject to a quarantine or isolation period related to COVID-19. 2. The covered employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. 3. The covered employee is attending an appointment to receive a vaccine for protection against contracting COVID-19. 4. The covered employee is experiencing symptoms related to a COVID-19 vaccine that prevented the employee from being able to return to work or telework. 5. The covered employees are experiencing symptoms of COVID-19 and seeking a medical diagnosis. 6. The covered employee is caring for a family member who is subject to a quarantine or isolation order or period, or who has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Or 7. The covered employee is caring for a child whose school or place of care is closed or otherwise unavailable for reasons related to COVID-19 on the premises. Written notice to employees is required. The employers must provide notice of the new law to their employees. The Labor Commissioner will provide a model notice for this purpose. Additionally, employers must list each covered employee's available COVID-19 supplemental paid sick leave either on the employee's wage statement or pay stub or on a separate writing each payday. This notice must be separate from the written notice of the employee's available regular paid sick leave, which is already required. Employers may require employees who are excluded from the workplace due to a COVID-19 exposure under the Cal/OSHA COVID-19 Emergency Temporary Standards. This requires an employer to maintain the employee's earnings when the employee is excluded to first exhaust their COVID-19 supplemental paid sick leave under Labor Code 248.2. Tax credits, though, are available. On March 11th, President Biden signed into law another COVID-19 federal stimulus package, the American Rescue Plan Act. The American Rescue Plan Act extends the Families First Coronavirus Response Act and the employer tax credits for providing supplemental paid sick leave through September 30th of 2021. Governor Newsom signed SB 95 into law on March 19, 2021, and it takes effect 10 days later on March 29, 2021. The law extends protections through September 30th, 2021, and is retroactive to sick leave taken beginning January 1st, 2021. This means that an employee can apply supplemental paid sick leave for any absence since January 1st that falls within a permissible use, as I previously described. Also, if an employer provided leave for any of the permissible uses on or after January 1st, 2021, the employer must true up the employee's pay for that leave to make it equivalent to the required rate of pay as required under the new law, in order to get credit for the previously provided leave. As more and more employees are headed back into the workplace, employers should review their COVID-19 policies, paid sick leave practices, and other employment practices with an employment attorney to ensure that they are complying with the many requirements to provide a healthy and safe workplace. With the numerous new laws that recently went into effect, many employers simply don't know what they don't know. Preemptive, preventative action by employers is critical to avoid labor code violations and the potential for employee lawsuits. I'm Tom Daugherty at the Kleindienst Law Firm with this employment law update. Feel free to visit our website at www.kleindienstlaw.com to learn about this and other important employment law updates.